Ladies and gentlemen, good morning and welcome. My name is Kian Kim, and as it was yesterday, I'll have the honor of being the host for the 8th International Conference on the Law of the Sea under the title Law of the Sea for the Next Generation, BB&J Agreement from Definition to Regulation. First, I'd like to thank all of your interest and support that you have shown for this conference. Like yesterday, this conference will be conducted both online and offline formats, and with live streaming available on YouTube. We have session 3 to 5 lined up for you today. Yesterday, we had insightful discussions on marine genetic resources, including the fair and equitable sharing of benefits and measures such as area-based management tools, including marine protected areas. As the host, we're deeply appreciated by your amazing presentations and panel talks and the passionate participation from the floor. So we'll now begin session 3 on environmental impact assessment of the BB&J agreement. His Excellency Markian Kulik, Judge of the International Tribunal for the Law of the Sea, will be the moderator for this session. Judge Kulik, the floor is yours.
Thank you. Good morning and welcome everybody. At the outset, let me also join the previous participants of the conference in expressing my gratitude to the organizers, in particular the Ministry of Foreign Affairs of the Republic of Korea and the Korean Society of International Law. I won't mention the International Tribunal being the judge, it wouldn't be appropriate, but definitely as a third co-organizers for an excellent organization of the conference. And it is my pleasure to welcome you all this morning at the third session of our conference, focusing on the crucial topic of environmental impact assessment. Under the theme of environmental impact assessment, this session aims to shed light on the challenges and opportunities that lie ahead in better understanding of the future of environmental impact assessment in the context of the law of the sea after the adoption of the BB&J agreement. Over the course of this session, we will hear from esteemed experts and scholars, but I also encourage all participants and all present in this conference to actively engage in the discussion, ask challenging questions, and to continue to understand our unique perspective. It is through a meaningful dialogue that we can have an interesting next 2 hours, I hope. Without further delays, it is my great pleasure to introduce our esteemed first speaker for the session, Dr. René LEFEBER. Dr. René LEFEBER is a distinguished legal expert and holds the position of legal advisor and head of the International Law Division at the Ministry of Foreign Affairs of the Kingdom of the Netherlands. In his role, Dr. LEFEBER advises the Dutch government on matters of international law, represents the Netherlands in international legal proceedings and intergovernmental negotiations. His expertise and deep understanding of international law make him a highly respected figure in the field. Furthermore, Dr. LEFEBER is also a prominent international law scholar, holding a chair in international environmental law at the Amsterdam Center for International Law of the Faculty of Law at the University of Amsterdam. His contributions to the study and development of international environmental law are widely recognized and appreciated. Today, Dr. LEFEBER will be sharing his insights on a topic of utmost importance, titled Assessing Environmental Impacts in Marine Areas Beyond the Limits of National Jurisdiction. As we navigate the complexities of the BB&J agreement and the challenges associated with the environmental impact assessment, Dr. LEFEBER's expertise will shed light on the crucial aspects of assessing environmental impacts in these areas. Dr. LEFEBER will provide valuable insights into the legal frameworks, challenges, and potential solutions related to environmental impact assessment in marine areas beyond national jurisdiction. His presentation promises to be enlightening and thought-provoking, offering a deeper understanding of the complexities involved in these critical aspects of marine conservation. Dr. LEFEBER, the floor is yours.
A very good morning to all of you. So let me thank Judge Kulik for his kind words and introduction of my presentation. Excellencies, colleagues, former colleagues who have become excellencies, ladies and gentlemen. Let me first thank the organizers for their invitation to address you at this conference and the opportunity to reflect on what we agreed earlier this year. So this part 4 on environmental impact assessments is so rich that I cannot address it all, and so I've decided to focus my presentation on screening of planned activities to determine whether an environmental impact assessment is required. So the law of the Sea Convention already recognizes that it's important to assess the potential effects of planned activities, Article 206. So it applies to activities under the jurisdiction or control of states. And it includes activities in areas beyond the limits of national jurisdiction, as well as activities within the areas of national jurisdiction. But there is a threshold, so not all the effects of all activities have to be assessed. Under the Convention, it's only those activities when there is a reasonable ground for believing that activities may cause substantial pollution of or significant and harmful changes to the marine environment. And then there's also a qualifier in Article 206, as far as appropriate. A well-known qualifier in international law, including international environmental law, that takes away some of the effect of the provisions. But it seems that this provision of the Law of the Sea Convention has never been applied, at least not with respect to areas beyond the limits of national jurisdiction. I have come across a few instances where it was applied to offshore activities in the EEZ. And in my own research, I have found no example where this provision was applied. And as a facilitator in the negotiations, 4 preparatory committees and 6 sessions of the Intergovernmental Negotiation Committee, I asked the question each and every time, no example was given. So let's have a look at a few activities that did take place over the last 15 years or so. So the first example is related to ocean fertilization. It's the so-called LOHAFEX project that took place in 2009. So this is a scientific climate engineering experiment, and it was conducted by research institutes from India and Germany. So the project involved the dissolvement of 10 tons of ferrous iron sulfate in seawater over an area of 300 square kilometers in the Southern Ocean. During an expedition of 70 days, the effects were monitored for 38 days. So what the dissolution of iron sulfate does, it creates an algae bloom, and then either the algal bloom dies and sinks to the bottom of the ocean and creates a carbon sink, or it has a biomass effect because it's consumed by higher organisms, both resulting in carbon sequestration. When this project was announced in 2008, it resulted in environmental concerns being expressed, including at the 8th Conference of the Parties of the Convention on Biological Diversity, where I was present at the time, and that prompted the German government to halt the experiment for a scientific and legal review. So the scientific and legal review took place, and then the activity was still allowed to proceed, and that happened in the first quarter of 2009. But without an environmental impact assessment conducted under Article 206 of the Convention. Apparently because the threshold was not met. I think what is also important is to realize that, presumably, I'm not an expert in German law, there was no domestic regulatory framework in place to assess whether that threshold was met. Go to the second example, that's the Ocean Cleanup. The Ocean Cleanup is a Dutch non-governmental organization, and its objective is to remove 90% of the floating ocean plastic pollution. It has two projects in place for that purpose, and one is the interception of plastic in rivers, and the other one is removal of plastic from the oceans. So for that purpose, it uses a floating structure that acts as a containment boom. There is a permeable screen 4 meters deep to catch subsurface debris. And there's also a U-shaped barrier of 800 meters that is towed by crewed boats. So the retention systems have been deployed in 2018, 2021, and 2023. Again, some environmental concerns were expressed. First of all, the system was inefficient. It's not the core of the problem. We have to stop producing plastics. It produces pollution itself. And also, it kills marine life by ensnaring organisms such as turtles. And this prompted the Ocean Cleanup to conduct an environmental impact assessment in 2021. It did a screening for potential impact for further analysis for an environmental impact assessment, or if no such potential impact was detected, then it would indicate that no impact was expected. It concluded, with respect to biodiversity, that there is not enough information at this time to fully address biodiversity impacts. And as a result, it concluded that no significant impacts to biodiversity are expected. So this was a voluntary environmental impact assessment. Again, it was not an environmental impact assessment under Article 206 of the Convention. There is no domestic regulatory framework in place in the Netherlands, and according to the voluntary assessment, the thresholds was not met, at least not for biodiversity. Go to the third example. It's an example of ocean disposal. This is Sao Paulo. This is a Brazilian aircraft carrier that was commissioned by the French Navy in 1963 and transferred to the Brazilian Navy in 2000. Apparently it was never used. And in 2017 it was demobilized and decommissioned subsequently. Then it was sold to be scrapped in 2021. Was to be transported to Turkey, but Turkey rejected permission to the aircraft carrier to dock, and it refused the permission under the Basel Convention on the transboundary movements of hazardous waste and their disposal. So eventually, the vessel was disposed of by sinking on the 3rd of February of this year. And this happened approximately 350 kilometers off the Brazilian coast. And according to the Brazilian Navy, it was just within the outer limit of Brazil's exclusive economic zone. Again, environmental concerns were expressed. The ship allegedly contains hazardous substances, including asbestos. However, a federal Brazilian judge decided on the 1st of February 2023 that a request for an injunction was denied because the Navy had weighed environmental impact against other factors. So again, we see here that no environmental impact assessment was conducted under Article 206 of the Convention. Again, presumably, There was no domestic regulatory framework in place. But in this case, I would wager, or I'm inclined to say, yes, the threshold was met. But yet, I come to the conclusion that there is no violation of the Law of the Sea Convention because sovereign immunity applies under Article 236 of the Convention. According to that provision, the provisions regarding the protection and preservation of the marine environment do not apply to any warship, and this was one of them. However, there is an important second sentence which is difficult to apply, and that is that still the state concerned has to act in a manner consistent so far as is reasonable and practicable with the Convention. But this was the past. Now we have the BB&J agreement. And so it is good to assess what would be different once the agreement has entered into force for the states, that it will enter into force too. Now, first and foremost, and extremely important, is that the BB&J agreement provides or requires the parties to establish a domestic regulatory framework for environmental impact assessments. So first, parties shall ensure that potential impacts are assessed. That's under Article 28, paragraph 1 of the agreement. And according to Article 53, parties shall take the necessary legislative, administrative, or policy measures to ensure implementation of the agreement. So that's already a big difference from the time before. I think the second important innovation compared to Article 206 of the Convention is the introduction of a tiered approach. Controversial in the negotiations, but eventually agreed to as part of the package. So this tiered approach provides for a screening threshold and an assessment threshold. If you look at the screening threshold, then you can see that there are actually 4 relevant criteria. One is more than a minor impact, and the second is a transitory impact. The third is the impacts are unknown, and the fourth, they are poorly understood. Now, the first two you can find also in the Antarctic Treaty Protocol on Environmental Protection. The last two were an innovation in this agreement, and I might say that they are there because the small island developing states insisted on them being included, and they eventually prevailed in the negotiations by having it at least in the screening part of the agreement. Now, if we now review the 3 examples that I just discussed with you, then when we look at ocean fertilization, probably not more than minor. It is transitory. The effects are not unknown because I think the scientists have already described the effects. But I would say they are poorly understood because, after all, this was a scientific experiment. So under the agreement, it means that screening would be required. The ocean cleanup, more than minor, probably not. Transitory, yes. Unknown, I would say yes, because they did a voluntary assessment and the impacts on biodiversity were unknown. Poorly understood, yes. So again, under the agreement, screening would be required. Then the third example, ocean disposal, the Sao Paulo. More than minor, yes. Transitory, no. And so for those 2 reasons already, a screening would be required. I would, in this case, say the effects are not unknown, at least assuming that the hazardous substances are present in the vessel that was sunk, and they're also not poorly understood. So, in all 3 instances I have described, I have discussed with you, the screening thresholds would be met and screening would be required under the agreement. Then moving on to the assessment threshold, you will find the same threshold as under the Law of the Sea Convention. So that's a relatively high threshold. So presumably, once you have done screening, My provisional conclusion would be that for ocean fertilization, no environmental impact assessment would be required. For the ocean cleanup, no environmental impact assessment would be required. For the sinking of the Sao Paulo, I would say yes on the basis of the threshold, if you would look at that alone. However, we have exceptions in the agreement. And there are 3 that I will discuss with you and also apply to some of the examples that we have discussed. The first one is that the provisions of Part 4 apply to activities in areas beyond the limits of national jurisdiction. However, after extensive debates, it was also agreed that activities within the limits of national jurisdiction causing effects in areas beyond the limits of national jurisdiction should be covered as well, at least to some extent, not necessarily the same provisions. So that's provided for in Article 28, paragraph 2 of the agreement. And there you can find that states have a choice to make. They can choose to apply Part 4, but they also can choose to apply their national process with some international safeguards or information and monitoring requirements that would be applicable. So let's go back to the example of the Sao Paulo, the vessel that was sunk in the exclusive economic zone of Brazil. So what is the importance here of the location of the sinking? So we have listened with interest to yesterday's presentation by George Pack, and I would agree with him that the high seas include the water column and seabed, including the subsoil thereof, beyond the territorial sea, subject to sovereign rights with respect to the exclusive economic zone and the continental shelf. So I would argue that the sinking of a vessel in your EEZ is a high seas activity. Hence, Part 4 would be applicable. There's no exemption to be applied here. Because if you would come to a different conclusion, you would say, no, the sinking of a vessel in the EEZ is within the limits of your national jurisdiction, then there are 2 alternatives. Either you accept that sinking may have effects in the area beyond the exclusive economic zone, in an area beyond the limits of national jurisdiction, in which case you have the choice on the basis of Article 28.2 to either apply Part 4 or apply a national process. However, if your conclusion is that the sinking of the vessel in the EEZ is within the limits of national jurisdiction and the effects will also be within the limits of national jurisdiction, then the agreement does not apply and you fall back on Article 206 of the Convention. I would like to argue that this falls actually under Part 4 as an activity in an area beyond the limits of national jurisdiction. However, the exception of warships is applicable under the agreement as well. And for that, you have to look at Article 4, which is a copy of Article 236 of the Convention. So it's the sovereign immunity that applies here as well, subject to the same provisions as you find in the Law of the Sea Convention. So moving to the second example, the second exception, that is activities that are also governed by other legal instruments and frameworks or the global, regional, sub-regional bodies. And here you can find in Article 29.4 2 exceptions. And one relates to the existence of equivalent assessments, and the other relates to systems or rules or regulations that have been designed to prevent, mitigate, and manage impacts and have been complied with. So now let's look at the first exception first here. So that is, what are mechanisms, what are instruments under which equivalent assessments are to be conducted. And the clear example here that comes to mind is deep seabed mining, so governed by the Law of the Sea Convention, a 1994 agreement that mentions environmental impact assessments. The mining code, and also, of course, I should refer to the advisory opinion of the International Tribunal for the Law of the Sea on deep seabed mining that addresses environmental impact assessment as well. So now if you look at the mining code, then you will find that for prospecting and the search for deposits, no environmental impact assessment is required. For exploration, under the existing exploration regulations, a preliminary assessment is to be conducted in order to apply for the approval of a plan of work. And under the contract to be concluded, you have to submit an assessment prior to commencement of your activities. So there is a framework there. And then when it comes to exploitation, looking at the draft exploitation regulations, you will find there in draft regulation 47 that an environmental impact statement has to be produced. So question now is whether that process that has been decided by the International Seabed Authority is equivalent to the process under the BBNJ agreement. I think it's good that the International Seabed Authority has the opportunity with the BBNJ agreement in hand to review draft regulation 47 and assess whether indeed the system that they are developing is equivalent to the system under the BBNJ agreement. Then let's move to the other exception, and that is activities subject to regulations or standards that are designed to prevent, mitigate, or manage potential impacts below the threshold and requires that they are complied with. So, example that comes to mind here is navigation. I think when you comply with the IMO regulations and standards for navigation, including MARPOL, that you actually will be covered by this exception. But I think the discussion that we can have here now, that we did not really have in the negotiations, is how does this apply to fisheries? And that's an interesting question. It's not a difficult, not an easy question to answer. It's a difficult question. But you could argue that if fisheries are governed by a regional fisheries management organization, that could fall under this exception, provided that RFMO operates in accordance with the precautionary approach and the ecosystem approach, including scientifically established maximum sustainable yield for fisheries. But what would apply if fisheries are not regulated by an RFMO? So there are certain areas in the high seas that are not regulated by an RFMO, or certain species are not regulated by an RFMO. Or what if a state is not party to an RFMO and still conducts fishing operations in such areas? Then the question is what other relevant legal instruments or framework means, and in particular, as I've done here on my slide, whether it covers only international regulations and standards. The question is whether it also would cover national regulations and standards. looking at the text, a pure textual interpretation, I said, well, it could also cover national if you look at Article 29.4. However, I think when you would pursue a contextual interpretation, also taking into account Article 5.2 that was discussed yesterday, the undermining provision, I think what we mean here is an international relevant legal instrument or framework. And that would mean that in such cases, fishing would not be exempted under Article 29.4. So we have a system with exceptions, but the application of the system can be tested. And I think the agreement is comprehensive in the sense that we have a few options to test any decisions under Part 4. The first one is very specific for Part 4, and actually for screening in particular, and that's the so-called call-in mechanism. And that's an innovation, I would say. I think it was frowned upon first when it was introduced, but then later it was accepted, but then limited to screening. And the call-in mechanism means that if a party, you have to be a party, but I would say it would apply to any party, has concerns with a screening decision of a country, of another party, then it can register its views. And if those views contain concerns, then that requires the other party that took the screening decision to give consideration to those concerns. And the views are not only registered with the party concerned, but they're also registered with the scientific and technical body. So you have the other party looking at it, and of the party concerned looking at it, and you have the STB looking at it. And the STB also can give recommendations to the party concerned. So the system is designed in such a way that the party concerned would have to take into account the views, concerns registered, as well as the recommendations of the STB when it comes to making a decision on the basis of the screening, whether or not it would require the conduct of an environmental impact assessment. So this is a new mechanism, still to be tested, but it should be relatively easy to use. It's not like an invocation of the responsibility of another state for a screening decision that is not compatible with the agreement. It's a simple process where you can register your views, including concerns that then have to be taken into account and to which consideration shall be given. The second option is, of course, that if you are concerned as a party with a screening decision, you can put it on the agenda of the COP. Of course, the rules of procedure still have to be developed, and so that would provide for the rules to put agenda items on the agenda. But under Article 47.6 of the agreement, the COP can consider issues related to the implementation of the convention. Interesting as well is 47.7 on advisory opinions. So advisory opinions can be asked by the COP to the International Tribunal, and can be requested from the International Tribunal for Law of the Sea by the COP. However, there's an exception for the regional and international frameworks for the IFBs in short. Third option is the Implementation and Compliance Committee to be set up under Article 55. And this Implementation and Compliance Committee is not yet operational, but it is to be facilitative and future-oriented. And it can consider issues at the individual and systematic level, so that would include screening decisions, it may make recommendations. Of course, the modalities and rules for the committee are yet to be adopted by the first meeting of the Conference of the Parties. And there, importantly, the COP will have to consider the triggers. So if you look at other compliance mechanisms, a discussion is always who can actually trigger the mechanism, who can bring an issue before the committee. So only a party with respect to itself, a party with respect to another party, the Conference of the Parties, or in this case, the scientific and technical body, or anybody else, including members of the public. That is something that still needs to be discussed. And fourth, and finally, there's the option to resort to the settlement of disputes. I would argue that screening decisions and other decisions related to Part 4 are not technical disputes and do not fall under Article 59, but they could become a question of interpretation or application of the agreement under Article 60. So, meaning that a party can unilaterally invoke the responsibility of the other party, or two parties can decide by a compromise to submit a question of interpretation or application to the ICJ, International Court of Justice, the International Tribunal for the Law of the Sea, or arbitration. And important is that the jurisdiction is compulsory, and important as well is that I would say all parties would have standing. Given the nature of the BBNJ agreement, the only conclusion can be that if one party has a concern with respect to the activities of another party, that it will have standing. So it applies erga omnes partes. So that brings me to my conclusions, and I've exhausted my time, but I take one or two more minutes to sum up. Part 4 is operational, like some of the other parts of the agreements, and it is operational for environmental impact assessment for planned activities in ABNJ, but also in areas within the limits of national jurisdiction. So we have a screening process, we have an environmental impact assessment process, 31 to 33. We have a decision-making standard, Article 34, paragraph 2, and we have provisions on monitoring, reporting, and review of authorized activities, Article 35 to 37. Envisage actions of the Conference of the Parties and the scientific and technical body is to further refine these provisions. It's Article 38, but it's not required for the part to be operational. So Part 4 looks like it may be effective, at least I would say more effective than UNCLOS. Reasons: it requires a domestic regulatory framework to be set up. It introduces this tiered approach, which requires screening, which will promote more informed decision-making on whether an environmental impact assessment should be required or not. And finally, there are options to test the implementation of the agreement. So yes, I think it was a great result of the negotiators. I'm proud of us. Thank you.
I thank Dr. LeFeber.